Ladies and gentlemen, we are coming to the end of this first annual forum on business and human rights. And in this last hour and a half or 2 hours, we have an opportunity to draw some conclusions and draw some lessons from what we've been hearing the last 2 days. It's been an extraordinary event, and I congratulate all of you and thank all of you for your engagement and for your commitment. We've had, beyond our wildest expectations, nearly 1,000 people register for this forum from 85 countries, representing all sectors of society. We've had very rich discussions, and the discussions have been very constructive and productive because they focused on how to make things work and how to make things work where they matter most, which is in the daily lives of people. That's why we're in this in the first place. This forum is actually intended as an ongoing activity, an annual ongoing activity. It is recognized in a Human Rights Council resolution, and it is intended to come together for people to reflect and share experiences and identify good practices and point out gaps in the implementation of the guiding principles. And so you as a body, as a forum, do have a life beyond our meeting for these 2 days, and it's an extremely critical role that you play. I'd like to make just a few concluding remarks myself, not attempt to summarize in any way the discussions. For one thing, there were so many different things going on simultaneously, it would be difficult to keep track of. But just some general observations from what I did here in the sessions that I attended and what colleagues have reported to me, and then we will hear other reflections from the members of the panel, and John Morrison will facilitate that discussion. I think we've had indications of good progress for a very limited period of time. 18 months is not a long time in which to turn around big ships, and both states and companies, and in fact even NGOs in some ways are big ships that are hard to turn around quickly. But nevertheless, I think we've heard reports that serious engagement is taking place, serious efforts at implementation and operationalizing the guiding principles are taking place. I found it interesting, I think I'm correct, in observing that the quickest response, the quickest uptake, in fact, has been by collective actors, if you will. And by that I mean other international institutions, like the OECD, the International Finance Corporation, the European Union, to some extent ASEAN, the African Union. Also by business associations, industry associations, by labor federations, by civil society coalitions, by bar associations. And I think that to some extent is understandable because these collective entities are better equipped to respond quickly to collective needs. And what we are addressing with the guiding principles are collective needs, the needs of people around the world. But nevertheless, we've also had good responses, as we've heard over the last 2 days, from individual states, companies, and NGOs. So I'm quite encouraged by what I've heard over the course of the last 2 days. So where are we, as it were, 18 months later? In an address to the UN General Assembly back in 2008, when I first presented the Protect, Respect, Remedy framework, I said to the General Assembly that the era of declaratory CSR is over. From henceforth, it is no longer good enough simply to state intentions. It has become necessary to know and show. It has become necessary for states to know and show that they fulfill their obligations under the international human rights regime. It is necessary for companies to know and show that they respect human rights, not simply to say that they do. In a way, the adoption of the guiding principles 3 years later, without being too grandiose about it, in a sense, for business and human rights, it was a bit like a constitutional moment. We now have a small c constitution for business and human rights. Now, like every constitution, the basic document itself doesn't solve or settle every concrete situation. Constitutions don't do that. They lay down general principles of how concrete situations ought to be addressed, how they should be dealt with, on the basis of what principles, on the basis of what norms. Now, the UN guiding principles, as you know, rest on complementary pillars, different but complementary pillars. And I want to stress that fact because there is often an inclination to take one at a time and treat it in isolation, but they're meant to work together. And in fact, the guiding principles deliberately draw on the different rationales, if you will, of the different players involved. And so for states, in the guiding principles, for states, the focus is on the legal obligations they have under the international human rights regime, the legal obligations to protect human rights, the legal obligation to protect human rights abuses by third parties, which includes business. It also includes policy rationales that are consistent with and supportive of meeting those obligations. That's pillar one. For business, beyond compliance with legal obligations in countries in which they operate, the guiding principles focus on the need for businesses to manage the risk of involvement in human rights abuses in line with international norms, with internationally accepted standards, which requires businesses to act with due diligence to avoid infringing on the rights of others and to address harm where it does occur. Then for affected individuals and groups, the guiding principles serve as a basis for further empowerment through prescribed engagement with them by business enterprises, as well as greater access to effective remedy, both judicial and non-judicial. And so you have different but complementary rationales, which, as I say, are meant to work together. They're not meant to substitute for one another. The idea is for this to generate a mutually reinforcing dynamic that produces cumulative change over time. That's the entire sort of strategic element of the guiding principles. Let me make one other point about the guiding principles. They include both preventative and remedial measures. And again, neither is a substitute for the other. For me, as I'm sure is true for all of you, the most urgent need is to reduce the incidence of corporate-related human rights harm to the maximum extent possible in the shortest period of time. And the obvious way to get started with that is through preventative measures. Prevention is also easier to achieve in lesser amounts of time than the challenge of judicial reform, to which I'll return momentarily. Prevention does not come at the cost of remedy. The two are not binary. The two are meant to go together. So many of the prescriptions for states that you see under Pillar 1 are for preventative measures, for states to undertake measures to regulate business so that business is prevented or is incentivized not to get involved in human rights harm. For businesses itself, the due diligence requirements are exactly that, to conduct adequate human rights due diligence to avoid infringing on the rights of others. And in Pillar 3, you have both judicial and non-judicial remedy. We know why judicial is important. We stress in the guiding principles that non-judicial mechanisms are also important. For one reason, because many of what ended up as the worst corporate-related human rights abuses started as lesser grievances that were not dealt with, that were ignored, that were escalated, and serious harm in the end was done. Much better to deal with those sorts of situations as early as possible and as quickly as possible. So let me say a word about judicial remedy. As all of you who've been involved in governance issues, in judicial reform, know very well, it's hard work and it's long-term work. The best friend that human rights has is the rule of law. But as you know, the challenge of establishing the rule of law is not accomplished quickly or easily. The guiding principles in Pillar 3 point out obstacles to judicial remedy and suggest some ways of dealing with them. But there is no silver bullet that is going to solve the problem in the short run and with one single shot. Extraterritorial jurisdiction, which has been much talked about in this domain, is an important instrument, but it remains highly controversial. The same countries that often complain about the power of multinationals and how it needs to be controlled are also the first to complain about extraterritorial jurisdiction, about the courts of other countries or the executive branches in other countries interfering in their domestic affairs, which narrows the scope for getting agreement on extraterritorial jurisdiction. Any proposal in that direction needs to be carefully calibrated and targeted. And indeed, there are areas where I think efforts are paying off. For example, I mentioned in my opening remarks where parent companies themselves are negligent through acts of commission or omission. It is an easier case to make that home country courts should be involved. And secondly, in relation to universally accepted prohibitions such as crimes against humanity, where, as I stated in my opening remarks, greater legal clarity about the applicability of those standards to legal persons is desirable and necessary. Let me say finally, on a personal note, that I've been a student and practitioner of these issues for longer than I care to remember. As you see from my hairline, I've been around for a while. I was in this building as a young assistant professor back in the 1970s, doing research and following the negotiations on the Code of Conduct on multinational corporations. If memory serves me correctly, that went on for 17 years, and it produced utter failure. It was then followed in the late 90s, the early 2000s, by the effort to develop the UN norms on multinational enterprises and human rights. It too was a failure. In 2011, we had a success. We succeeded where previous efforts had failed. We now have a strong foundation on which to build. Let me express my gratitude to you for your willingness to help build on it in order to achieve concrete results now that we have the starting point that we've lacked in the past. I have no further role in this process. I am now emeritus, but I will be watching very closely and with great interest to see how this evolves over time, and I'm delighted to congratulate again the working group and to wish them all the best in overseeing the process of implementing the guiding principles for the duration of their mandate as well. So thank you again for your interest, your commitment, and I now hand it over to John, who will direct us through the remainder of the afternoon. Thanks.
Thank you, John. And on behalf of the Institute for Human Rights in Business, I'd like to briefly also thank the Office, the Working Group, and the government who've supported the forum. In a couple of minutes, I'm going to introduce the panelists to my left, and we'll start the session the way forward, opportunities and priorities for action by relative actors. And I guess one thing to say before we do is this discussion isn't just about the forum or the role of the working group. Commentators here have been briefed to speak about challenges across the whole arena of business and human rights, and I suppose to itemize within that the role that the forum might play as one tool amongst many as we go forward. And just to reiterate something that John said, it's clear that there are gaps. Several people have mentioned protection gaps over the past 2 days, and the recent fires in Pakistan and Bangladesh remind us of how even audited factories can cause huge numbers of fatalities. And similar examples from around the world remind us that existing measures are not enough to give adequate protection for vulnerable workers. Now, the mandate of this forum was agreed on the 6th of July 2011 by the Human Rights Council, and it's very fitting we're in room 20 at the same time as the mandate for the working group was agreed. And I'll just read the paragraph, the relevant paragraph from the text, that this forum on business and human rights would work under the guidance of the working group to discuss trends and challenges in the implementation of the guiding principles and promote dialogue and cooperation on issues linked to business and human rights, including challenges faced in particular sectors, operational environments, or in relation to specific rights or groups, as well as identifying good practices. So, with that in mind, I think the forum, everybody in this room and the 1,000 people who attended the past 2 days, we all have a stake in the future success of the forum. And the stakeholders to my left, and then later the working group, I'm sure, will comment on ideas and thoughts about the way forward. We will, after brief remarks from the 4 panelists, come to questions. It will follow the usual procedures of the question list. So if you do have a question and you haven't put your name on the list, please do so. We have about 50 minutes for Q&A, and I'm pretty sure we won't get through all the requested interventions. We'll try to do as many as possible. So if you could leave interventions to a maximum of 2 minutes, that will create more time for others to come in. Anybody who wants to submit a written statement to the Office of the High Commissioner for Human Rights by the end of Monday, I believe, will have that published on the website with the report that will come from this forum. So without further ado, I'd like to now introduce the first of our panelists, Sir Mark Moody-Stewart, who is the chairman of the Global Compact Foundation. Sir Mark.
Thank you. Thank you very much, John. Is that working? Yeah. First of all, I'd like to add my congratulations to the working group for what was obviously has been a very successful forum. Normally, if you took 1,000 people from business, civil society, UN agencies, and put them in a series of rooms and asked them to talk about business and human rights, they'd be like 1,000 cats. They'd be fighting in one corner, making love in another, and some of them had been just making a mess on the carpet. The fact that that has not happened, and that is somewhat of a reflection of what went on in the 17 years that John Ruggie talked about, and subsequent years. The fact it hasn't happened is as a result of the framework and the education process which John Ruggie took us through. We in business, and I believe civil society and others, and I think John Ruggie himself would say himself, were educated by this process. And the robustness of that framework has meant that in the discussions, they've actually been focused and framed and kept on track. And that's an enormous compliment to the achievement of John Ruggie. And I would like to, on behalf of business, but probably everyone else, thank him very much indeed. I was delighted at the meeting to see so many people from Global Compact networks around the world. There are 100 of these. And it's there that action actually takes place. The Global Compact has 7,000 signatories scattered all around the world. They are working on the principles of the Global Compact. We were slow on human rights in the last 5 years. That's grown enormously. We now have a very strong working human rights working group, but also groups on women's empowerment principles, children's rights, and so on. It is a multi-stakeholder group, and it's most importantly half in and half out of the UN, which allows us to operate sometimes slightly more rapidly than those fully in the UN. It's multi-stakeholder but business-led, and it's originally government-funded but now largely private-funded. But the 50 million people that those companies employ are a tiny fraction of the global workforce. And the really important parts are those in small and medium-sized enterprises. And it's only through the local networks and action on the ground that we can address these issues. John Morrison asked us to highlight 3 or 4 learnings. The first one is from this forum, I think, is in fact small and medium-sized enterprises. It is essential that we make progress in those areas. I attended sessions where we discussed the role of industry, of employers' organizations, which is very important, of chambers of commerce, and so on. And those are important bodies. But the great advantage of the Global Compact local network is that they are multi-stakeholder. They bring in civil society organizations, local civil society organizations, small enterprises, larger national enterprises, multinational civil society organizations, and multinational companies. And that grouping, I think, is extremely powerful in transmission of learning, and whether you're talking about supply chains, education, not just education of small businesses, education of big businesses about the challenges of local society. And that multi-stakeholder nature makes it extremely important and robust in being able to challenge some of the issues locally, and issues which may be misbehavior or inappropriate action by governments. The second issue was capacity building. Everyone stressed the fact that we had to build capacity around the world. Now, I think you can split capacity building into capacity building of governments, and that's a big issue. I think it's not one in which business can play a role, so I put that on one side. But the capacity building of business and civil society, local businesses and local civil society, is something which business can play a role in. And I think it's a fundamental role, and one, again, which through the Global Compact local networks can be done. Thirdly, I think there were sessions on the finance sector and investors. Businesses respond to a couple of groups of people. One are consumers, clearly, but the other is investors, our owners. And through something called the Principles of Responsible Investment, developed with UNEP-FI and the UN Global Compact, 1,000 long-term investors, pension funds, have committed to some principles of responsible investment. That is just beginning, but there is very important work going on in what investment is needed in countries in transition, countries which are not yet completely stable, perhaps a Sudan or a South Sudan or a Myanmar or an Iraq, where investment is necessary, but it has to be responsible investment. And we all know that there are enormous difficulties in making sure that the investment is responsible. But I think those principles for responsible investment and the support of long-term investors, not just to get companies to divest and say, get out of there, because as societies rationalize, we need investment, but it has to be responsible. Big problem, but a very important one, and investors play an important role. Lastly, education. Time and again I heard education mentioned. Education, clearly from a very early stage, from primary onwards, so that people know actually what their rights and what the rights of us humans are. But at a later level, I think through business education, and it was pointed out that many small businesses, medium businesses owned by families very often attend business schools. And again, I would commend to you the Principles for Responsible Management Education, which has, I think, over 400 business schools right around the world in very many countries, committed to deliver responsible management education, sustainable, but also incorporating such things as the framework. Those were some of my takeaways. Thank you very much.
Thank you very much, Sir Mark. Now Professor Anita Ramasastry from Washington University School of Law.
Thank you very much, John. Congratulations. I'll add my congratulations to the working group as well.
Microphone, please. Your microphone's not on.
I thought it was on. I'm sorry. I'll start again. Take two. I also want to thank and congratulate both the Office of the High Commissioner and also the working group. You've done an extraordinary job, the members of the working group, in actually reaching out to so many of us personally and learning about the different projects and activities that the different stakeholders are engaged in. It's a tremendous feat, and I just encourage you to keep up that level of connection with all of us, because it's made a difference in our feeling included in this larger endeavor. So thank you. Just a few observations, and again, academics sit in the back, and it's very easy for us. We write articles and criticize all of you, so don't take anything, but my reflections here are a couple of things. The first is on Pillar 1. Professor Ruggies mentioned that there's really been strength in collective action from civil society, business, and states, and I would agree with that. But what we haven't seen yet is really the proof in the pudding with respect to where the action has to take place on the state front. And so I hope in the coming year, we've heard that many states, EU member states in particular, are developing national action plans, and they're working groups, and they're going to take stock and unveil. So I sort of feel like this is a debutante's event, and next year we'll hear more. And with that, I hope that states really will come out with robust action plans as to what they are going to do. And as we've heard from different stakeholders and researchers over the week, there's a lot that can be done with respect to just existing laws, that I hope states will take stock using different tools to say, we already have things in place, especially with respect to our own national jurisdiction, to basically enhance our duty to protect human rights, and that there are opportunities for embedding the guiding principles in many places where government already interacts with the business sector and asks them to demonstrate and make commitments that are related to human rights in labor, social, environmental, and other areas. So really, the Pillar 1 is the place where I sort of feel like we've gotten a preview. Someone's sort of shown us a little bit of their leg, but I hope that we do see more. And I hope that we see more with respect to bilateral engagement. There's regional engagement, but what we need, again, collaborative learning and spaces for organizations to gather exist. Civil society and business are already doing that. But for states to really meet with one another and to build capacity in a safe space. And I know that the working group has talked about collaborative learning opportunities for states, and I really encourage you to do that because we need champions, but we also need bilateral engagement across different jurisdictions because we've heard from a representative from the African Union, for example, about the challenges they're facing in a regional capacity, and they need to really cross divides. So bilateral collaboration. Second point is with respect to Pillar 3, and I think that's the place where we're all feeling that that's where we need to put greater emphasis in the future. And for me as the academic, I thought it had been settled, and I think others had as well, but Professor Ruggie has really shown us that there still is a need to clarify at the international level the responsibility or accountability of companies with respect to gross human rights violations and of the legal capacity of states to sanction them. So I hope that this is something that the working group will seriously consider as well, which is how can we actually clarify this and settle this and get states to make affirmative statements. The last piece is looking forward. You've heard about finance and investment, and I think that is important. Another area, and one of the gems, I think, of the prior mandate were the principles for responsible contracting. States and companies interact together on a contractual basis. And those contracts have peril and have promise. And so those principles and further elaboration of those principles, I think, will really help us to think about how in a different way we can actually contractualize the guiding principles. And so I would really encourage the working group again to think about that. And the last piece is just transparency and disclosure. We've talked about it in different ways, and we've heard that it's very important as part of Pillar 3 that civil society does have access to information. So one of the things that I hope that the working group will do is think about there are many initiatives that are being undertaken at the international and multilateral level around the importance of open government. So I think one of the things to think about is, are there ways to just look at those existing initiatives and see how the guiding principles and this movement to create greater disclosure can be intertwined. So thank you for this opportunity, and I look forward to your comments.
Thank you very much, Anita. Next is Chief Littlechild, who is chair of the Expert Mechanism on the Rights of Indigenous Peoples.
Danse, as you heard, my name is Chief Wilton Littlechild, and I bring you greetings from the Cree Nation. All your excellencies, all delegates. On behalf of my colleagues at the UN Expert Mechanism on the Rights of Indigenous Peoples, thank you for this great honor. Allow me also to begin by congratulating and thanking the working group members and support staff for truly a historic and successful first forum. You embarked on a very ambitious work plan, and with your tireless efforts, you reached your goal. Yes, we have a lot of work yet to do, but I'm confident with all the valuable input given by all participants here, we have a great start. So thank you also to all delegates. Over 1,000 we heard in over 85 countries, but also all those who followed on information technology. As chairperson of the Expert Mechanism on the Rights of Indigenous Peoples, the newest UN mechanism for Indigenous peoples, we're a research-based advisory body to the Human Rights Council. So it's with gratitude that I offer some priorities for going forward. Before I do, however, please allow me to share some highlights. Many years ago, I was the chairman rapporteur for the first UN expert seminar on private industry states, human rights, and Indigenous peoples. Sadly, not much has changed. We called for a code of conduct for development on Indigenous territories. We continued to call for the respect and honor of our treaties. Yesterday, at the opening session, we heard about Indigenous men, women, and children being killed. We heard in side events of ongoing violations and abuses by state governments and/or corporations. But now, a change is possible. There is new opportunity. I'm so thankful that the working group has decided to focus on Indigenous peoples' issues. For me to see such consideration, serious consideration, to see such inclusion of Indigenous peoples in the work plan gives me great hope. Of particular note was the specific lens put on the experience of Indigenous women and the challenges of implementation for business affecting Indigenous peoples. We also heard an important call for action. What are we as lawyers doing about access to justice, it was asked. I should briefly mention that we, as the expert mechanism, are holding a seminar on this very topic of access to justice. This leads me to offer some thoughts for the way forward. As a wise Cree elder once told us, you must know where you came from, know where you are today, if you're to know where you are going tomorrow. Having assessed all the guiding principles from an Indigenous perspective, we offered a comment for consideration. We think going forward, we could work together collaboratively, hopefully including the Working Group on Business and Human Rights, the Special Rapporteur, the Permanent Forum, and the Expert Mechanism. Secondly, noting that there were very few Indigenous business owners present at the first Business and Human Rights session, we should consider a global summit on Indigenous business to further promote awareness of the Promote, Respect, and Remedy framework and reconciliation through business. Thirdly, we would respectfully urge consideration of the positive recommendations from the discussions in this session that advance the rights of Indigenous peoples. For example, the central role of national human rights institutions and the legal profession, among others. Fourthly, consider fully the recommendations of the Indigenous Preparatory Meeting in Copenhagen from the 5th and 6th of November. Indigenous peoples present recommended that within the mandate of the working group, that it uses the UN Declaration on the Rights of Indigenous Peoples as a framework for implementation of the guiding principles and the work of the working group. Secondly, builds strong cooperation with other UN bodies and mechanisms on Indigenous peoples' issues, such as the Special Rapporteur, the Permanent Forum, and the Expert Mechanism. Thirdly, include Indigenous peoples as a standing agenda item to the meetings of the working group, or as we heard here yesterday, have an informal side event pre-forum as a review of developments. Build on the awareness of the working group among Indigenous peoples, thereby contributing to promoting the effective and comprehensive dissemination and implementation of the guiding principles. Build awareness on the rights of Indigenous peoples among states, businesses, and other stakeholders, and provide guidance on how the guiding principles could be implemented with the full respect for such rights as those enshrined in the UN Declaration on the Rights of Indigenous Peoples, as well as the ILO Convention 169. Request states develop their domestic legislation and policies to implement the guidelines, the guiding principles, with the full and effective participation of Indigenous peoples. Our personal thanks to Working Group member Pavel Solyanziga for all his work to ensure the inclusion of Indigenous peoples, and indeed, all expert members. Finally, we're not just vulnerable groups or stakeholders. We are also business owners. We are rights holders. When states protect, when corporations respect, when due diligence is conducted, when remedies are considered, they must include and consider the rights of Indigenous peoples. Then we will have a win-win balance. We are very encouraged that the working group plans to present a report to the General Assembly on Indigenous peoples and business. And we pledge you all of our continued support. From the four directions, merci beaucoup. Muchas gracias. Hi, hi. Thank you.
Thank you very much, Chief. And finally, Mr. Aret van Heerden, President of the Fair Labour Association.
Thank you very much, John. And let me also add my congratulations to the work of the Special Rapporteur and to the working group, who I think have given us a framework that we now have to build upon and implement. And I want to just have a look at what that implementation will entail. We're dealing with global supply chains, which span many different jurisdictions, many of them characterized by governance gaps. And a global supply chain which is in a state of considerable flux. It's a living organism that is volatile, to say the least. And the financial crisis has only added to that volatility. We have even greater commercial pressures within that global supply chain. They start with consumers, they play out all the way down the chain, and they impact on the workers and communities at the other end of the chain. And one of the things that goes down the chain is this unbelievable volatility in the main consumer markets now. So companies are finding it very, very hard to plan for the demand that they could expect to find in the next season, the next peak season. Which means orders which are placed later and later with shorter and shorter lead times and with lower or the lowest price possible, which again places incredible pressure on the workers and communities and the resources involved at the other end of that chain. This also means that employers don't know what kind of staffing, what kind of human resource requirements they will need to meet those unpredictable demands. So they don't hire people on regular contracts. They maintain the smallest possible core workforce. And when they do get an order, they suck in short-term workers, often through a labor broker, often through a rather sketchy labor broker, often workers who've basically been trafficked to that destination. So we have an increasing uncertainty in the global supply chain that is working against us, frankly, and which is creating conditions in which people just trying to survive, just trying to get through their basic work, are taking chances. They're forced to cut corners. And they're not really in a position, to be frank, they're not in a position to play by the rules. It's becoming harder and harder to play by the rules, the framework which we would all like to see implemented. Young people in many of these countries have got very little chance of finding a job right now. So they choose to travel for work. How do they get out of their country? What's the framework? What's the channel for going abroad to seek employment in a regularized, ethical, monitored way? There aren't many. They often end up talking to some guy on the corner, demands a recruitment fee, the banks won't lend them money, they go to a corner money lender, they got an exorbitant interest rate, and they end up in some kind of debt bondage in a job in one of our factories, in one of our mines, in one of our retail stores, who knows? It's a very, very risky global labor market we have right now. So that's the first thing I'd like us to be just candid and frank about. The second thing is that I think the societal expectation of ethical trade no longer focuses just on a factory or just on a mine or just on a farm. There's an expectation that the supply chain out of which those commodities or products emerge is ethical. And so our focus is going to have to be the supply chain. And, you know, sustainable supply chains is by now a cliche. What it means is that you actually know a lot about your supply chain, from raw materials to recycling. I think the social audit is hopefully already a thing of the past. I think we've moved beyond that. But we're now going to have to get really good at tracing our products. We're going to have to get really good at mapping the risks, labor, human rights, environmental risks in those chains. And once we know what's out there, we're going to have a duty to act, to remedy. And if you just think of the scale of that exercise, there's no way a single company or even group of companies or organization could mobilize those remedies on their own. So it's basically going to mean a lot of stakeholder engagement. But stakeholder engagement, I would venture to say, of a new variety, a new generation. This is not going to be going out with a report to ask stakeholders for their feedback. It's not going to be inviting people to an annual get-together to exchange best practices or something like that. It's going to be going out there to seek solutions to problems we don't really know how to solve right now. It's going to mean talking to a very, very diverse group of rights holders and stakeholders who are going to disagree. It's going to be something a lot more like a collective bargaining round than a stakeholder consultation as presently defined. And this is going to mean a whole new skill set, a whole new vocabulary, probably a whole new language for all of us to learn. And so I predict that we're going to need, we will see a lot more coalitions and alliances built around issues at lower levels or higher levels of the supply chain, which are going to mobilize and test all of our resources. Just look at the environmental consequences of a lot of our activities. And look at the resources out there, look at the regulatory mechanisms, look at the existing activities around those environmental impacts, and ask yourself, what do we still need to bring to the table in order to address those? And the answer is pretty much everything. So I would imagine that as we meet in future years, we're going to be looking at the supply chain, the life cycle of the product, and we're going to be looking at all of these issues in an interrelated, multidimensional way. And we're going to be humbled by the enormity of those tasks. So it's going to take all of the goodwill that has been generated by the work of the Special Rapporteur and the working group to date, and some. And I cannot stress too much, I spoke yesterday about the safe space, the need for safe spaces in which to address those issues. Safe spaces which are not comfortable by any means, contested, sometimes adversarial, but ultimately problem-solving, outcomes-driven safe spaces. Thank you very much.
Thank you, Arette. I've been told that the question list is open for another 5 minutes. Just so you know, we have questions from states and national human rights institutions, I can see, and I can also see quite a lot from civil society. I don't have a single question from business at the moment on the list, so don't complain that there's no business voice in the next 50 minutes. If you would like to sign up, anybody would like to add their names, please do so in the next 5 minutes over there. Questions can be directed obviously at the four panelists, but also I think to Professor Ruggie. I think the whole point of me facilitating this is that the chair, you can ask questions to the chair, which doesn't normally happen, or reflections or challenges to us all. So we'll start with Michael Swan from the European Union, and please keep all interventions within 2 minutes. Thank you very much.
Mr. Chair, on behalf of the European Union, I wish to thank the OHCHR for its support to the forum, the working group for the organisation of the forum, and for all the facilitators of the parallel sessions for leading us through a constructive 2 days of discussions. Together, we've enjoyed valuable exchanges of a unique scope. The key thing now is implementation looking forward. In this regard, the EU takes away a number of important messages. First, the work will need to continue on all three pillars of the UN guiding principles. That is to say, the state duty to protect, the corporate responsibility to respect, as well as the access to remedy. We shall continue sharing experience with other countries and regions. It is important that there is continuing full support to the UN Working Group and its valuable cross-regional approach. It will be equally important to set clear priorities and to continue to apply the evidence-based approach of Professor Ruggie, so as to learn from the very practical experiences of businesses, human rights defenders, governments and trade unions. The full involvement of civil society in the activities organised by the working group will be required to maintain a true multi-stakeholder approach. The European Union remains fully committed in this phase of implementation of the guiding principles and will continue to take tangible steps to further develop its policy. The European Union will play an active role in the regional forums to be organised under the aegis of the working group. And finally, we must keep in mind the ongoing urgency of addressing the very real problems affecting real lives that we heard about in the opening session and the sessions on judicial and non-judicial remedies. Our collective ability to implement the UN guiding principles will be measured against the capacity to prevent human rights violations and ensure prompt and effective access to remedy where such violations occur. Thank you, Mr. Chair.
Thank you, sir. Now, Annabella Syrian from the Dutch Platform Against Impunity.
Muchas gracias.
Thank you very much. One of the main ideas that has been shared in this forum has helped us to identify some challenges for the implementation of the guiding principles in the future. The first is that this implementation will help enterprises and states to understand that free, informed, and advanced consent of indigenous peoples can take time, but the results will be better for all. Second, the implementation will also contribute to helping enterprises and states to understand their responsibility to defend the rights of indigenous peoples and to not criminalize those actions. Finally, I would like to ask the working group if they have considered in the context of the recommendations for judicial and non-judicial remedies to involve indigenous peoples in dialogue on these matters. Thank you.
Thank you very much. I now call on Dr. Musa Bariazat, who is the Chairperson of the Coordinating Committee of National Human Rights Institutions.
Thank you, Mr. Chairperson. For the sake of time, I will really skip with some trepidation the much-deserved words of much-deserved appreciation and admiration for all those who really brought about this event. As nationally established human rights institutions working under the umbrella of the ICC, comprising institutions from Africa, America, Asia, Pacific, and Europe, guided by international human rights principles, we are committed and we are really determined to work on this much elaborated upon point of what we call the implementation gap. Because of our situation, the way national human rights institutions have been established, as institutions independent, almost totally independent from governments, but working on international principles, totally committed to those principles, we are, I think, ideally well placed to work on this implementation gap, owing the trust of all stakeholders. Our work on this subject is well established. I think those who follow the work of the ICC will recall the 2010 Edinburgh Declaration on this subject. The key message I really would like to leave with you here is that as National Human Rights Institution, we will remain committed to work on business and the human rights issues with all stakeholders as universal, interrelated, interconnected rights without discrimination whatsoever. We also will continue to exercise our unique role as a bridge, as I mentioned, and we hope that this forum and the UN Working Group will help us to gain some space. I wonder if Professor Riggi and the president of the working group, we need sometimes some space within UN forum to make our voices and our assessments, both from the plaintiff and the defendants, if I can use the legal terms, heard objectively and independently. I thank you, sir, for this space.
Thank you, sir. I now call on Mr. Lazaro from Tupaj Amuro.
Señor Presidente.
Chairperson, on behalf of Indigenous peoples, I would like to thank Professor Ruggie, the representative of the Secretary General, who has presented us with a number of reports under the Human Rights Council, in the Human Rights Council framework. There are a number of concerns that have been voiced in that regard. And there was also a presentation made on human rights in business by a representative of Harvard University. And I wish to thank them for their participation in this event. We have been participating in a significant dialogue among representatives of banks as well as some institutions and governments. But Indigenous peoples were absent in that dialogue. My question is as follows. What should the legal nature be of the guiding principles? States and the working group, and as Professor Ruggie has said, should they act in the context of the United Nations guiding principles, or should there be a covenant or a treaty? What we're talking about here is the legal nature of that instrument. Then to whom should this document be addressed? Should it be drafted at the level of the Human Rights Council, by ECOSOC, or by the General Assembly? This is a very important point, and it must be taken into account in order to ensure that this initiative is effective in the area of human rights. With regard to the guiding principles, the governments of the South, which are home to some of the subsidiaries of multinational corporations, can apply national jurisdiction to those companies operating in their territory. Or does the jurisdiction of the headquarters of those companies apply? So what mechanism should be in place? For Indigenous peoples, this is not clear. As well as dispute settlement, this is another issue. There should be a mechanism in place for arbitration as well, because inevitably there will be conflicts. I will conclude shortly. Free and informed consent is an important issue. Indigenous peoples cannot have access to their natural resources, defend their land without having free and informed consent. This is a fundamental principle, and it is enshrined in many United Nations agreements and treaties. Having said that, Indigenous peoples are not confident in the guiding principles. It seems to be a general declaration of the United Nations, and who is going to respect that? neither states nor other parties. The most important point is to draft a binding legal framework for states and multinational corporations. Thank you.
Thank you very much. Can I ask for Mr. Toro, Edgardo Toro from the state of Venezuela?
Thank you very much, Chairperson. The Bolivarian Republic of Venezuela recognizes the efforts that have been made to hold this first forum on business and human rights. We believe that the work of the forum and its results can make an important contribution to efforts to address the issues that surround the violation of human rights by transnational corporations and other private sector enterprises. We are aware of the need for transnational corporations and other enterprises to assume their commitment to ensure that human rights are respected. In doing so, we consider the track record of those enterprises and some of their systematic violations of fundamental rights throughout the world, which has occurred with total impunity. That situation requires the decisive action of the international community to ensure that those corporations take responsibility for their actions. This involves actions such as prevention and including compensation. It is true that this climate of increasing demand to establish significant controls on abusive business practices calls upon states to take on legal obligations to protect people from such abuse. However, businesses also bear responsibility on the basis of international human rights law. Those responsibilities are applied universally, and they cover a wide range of rights. The transnational nature of this problem requires the regulation of the activities of transnational corporations and the establishment of mechanisms for enforceability for their activities, which go beyond national borders. In this way, this will guarantee that these companies comply with national norms and legislation when they operate outside their borders. The Venezuelan government believes that efforts to promote the guiding principles are indeed an important step towards recognizing the fact that transnational corporations have responsibilities in the area of human rights around the world. We are convinced of the need to establish extraterritorial mechanisms, global mechanisms for oversight and enforceability. We therefore believe that the development and the promotion of guiding principles must serve as the foundation for efforts to move forward in efforts to prevent and provide reparations for violations of human rights linked to the operations of these enterprises. And also, they must be held accountable. Thank you.
Thank you, sir. Mr. Dwight Justice from the ITUC.
There is no sound coming from the microphone.
Sorry, it's working. Yours is on now.
Thank you. You know, before the guiding principles were adopted, there were CSR conferences, which featured a long string of companies recounting all the good that they do. Good even where the...
I'm sorry, the microphone is off.
Try again. Where the labor laws don't exist, just the last phrase.
Where the labor laws don't exist. But anyway, I think that'll still happen. But there will be other now opportunities for us to discuss what's really on our minds. which is the adverse impacts of business on our human rights, and the opportunity to discuss what responsibility really means, and then that would be the consequences of one's decisions and actions, and in this case, the need to have due diligence. Now, I want to thank John Ruggie for everything you have done over the years to carefully build the kind of consensus that would bring us all together and realize that this is not the time to privatize the role of government. And I think that if there's a lesson to be learned there, it's that. Freedom of association is another human right that, broadly understood, is not only a right to be protected, it's also the right to protect rights. And that's why for workers it's the thing that is on our mind most, because what we really want from the state and from business is a recognition of our right to protect ourselves. Now, when we talk about looking about the way forward, I think we have to realize that what we're in should not become a static process. But what I would urge is two things. One is that the process as it moves forward with the same kind of seriousness in which the process that got us to the principles was, and that it not degenerate into slogans or into imitations of CSR conferences or that sort of thing. But the other thing I wanted to say is all three pillars must move forward. And I think that what that really means now is we need to look to the states and the international organizations to make some concrete moves. Thanks.
Thank you very much. Ambassador Dusan from the Republic of France.
Merci, Monsieur. Thank you, Chair. I would also join in the congratulations extended to John Ruggie and to the expert group who have shown, through the very interactive way in which these days have been organized, have shown the importance of teamwork, of working together, of a dynamic group moving forward. I'd like to propose two things for this interactive discussion. First of all, basing myself on the statement made by Professor Ramasastry this morning and also this afternoon, who drew our attention to the fact that much is being done in a large number of states and international organizations on the subject of transparency. And one of the ways of encouraging companies to be transparent is to have them to provide reports on their activities, on their social, environmental conduct, and human rights conduct, and also with respect to consumers. Some governments, and I come from one of those governments, have even deemed that it is through these legal obligations that you can make progress in these issues, with the ultimate goal perhaps one day of achieving an international norm which would make transparency based on common principles in all countries. What I would like to emphasize is that, be it through legislation or be it through a strong push by governments, be it through regulations by the stock exchanges, what we have at present is a kind of momentum, if I can use an English word. We can feel a momentum because in various regions of the world we can see that this subject is now being given serious consideration. In Asia particular, several stock exchanges have made it mandatory for companies quoted on the exchanges to provide this information. And on the subject of due diligence, I think we still need to be inventive here, and I think that this is why it's important for the working group to spend some time on the subject, because when you ask enterprises to submit reports on their impacts, the question always arises, Should it be for the mother enterprise? Should it be for the subsidiaries? Should you also include their main suppliers, or even go beyond that? This is an issue for all legislators working on the issue of reporting. It's an issue that the European Commission has been said is also tackling and preparing the directive in the EU on the subject. And I think there's a clear intellectual link between due diligence and reporting, but the legal link still has to be found. You know that a number of countries have taken advantage of the fact that recently in Rio, the declaration included a paragraph 47, on this very subject. Some countries have taken advantage of that to start thinking about the issues. Countries from different parts of the world, South Africa, Brazil, and European countries, two of them, Denmark and France. Norway has joined us. We like to bring in more countries to work on this particular issue. Since I cannot get to my second question, since I'm running out of time, as my chairman has pointed out to me, I just wanted to say that my second point would have been protection of victims. This is a serious issue. We're all very moved by the statement made on the very first day on this subject of victims. On this, we would have also had suggestions to make, but we won't be able to, so we'll do it at the next conference. Thank you.
I'll remind the ambassador that statements can be submitted in writing in the next 3 or 4 days. Adam Green from the U.S. Council for International Business, please.
Thank you, John. And I'm really only speaking because you invited a business speaker, and so it's really your fault, whatever I say. So anyone with arguments should speak to John. I think 3 quick points. The first is that the dissemination of the guiding principles has really just started. There is a very small community of mainly very large companies that's very much aware of the guiding principles. But awareness falls off fairly rapidly after that. So it is seen as an objective within the business community to disseminate the guiding principles as widely as possible. So the International Chamber of Commerce, the International Organization of Employers, the Business and Industry Advisory Committee, and any other sort of global business network that has large memberships is going to be involved and is currently involved in getting the guiding principles out as widely as possible. And again, this is not a reluctant effort. This is a very much a participatory effort and encouraged within the business community. The second point is that a key strength of the guiding principles is that they apply to everybody equally, all enterprises. And one of the issues I've noticed in this discussion over the last 2 days is that there's a lot of focus on multinationals and foreign investment from the outside looking in. And I think a key point of the dissemination within the business community is to get directly to national audiences so that these issues can be debated within a national context in national institutions and national actors. And it's not some voice from the outside speaking or preaching into you. Solutions can be developed locally, and I very much endorse Auret's notion of safe spaces to tackle some of these very difficult issues. And the last point is to really agree with Dwight Justice at the ITUC that the role of states and governments are very distinct, but as built into the guiding principles, they're interrelated. And the ability of a company to be corporate, to respect the principles is really shaped by the operating environment where it is. And 2 factors, I think, that really need to be put on the table very clearly are corruption and informality. In any country that has high levels of corruption and high levels of informality create institutional barriers to the corporate responsibility to respect, as well as the state duty to protect. And those 2 issues alone, I think, are worth a lot of time and attention and serve as sort of fundamental barriers to moving things forward. Thank you.
Thank you, sir. Now, Ms. Hannah Leck from the ELSA European Law Students Association.
Dear participants, distinguished panel, I would first want to thank you all in meeting up here from all over the world and all kind of nations discussing this highly important topic of business and human rights. That leads me to the question which is basically addressed to both the panel and the working group. So I would like to know if the working group has thought about making it mandatory for states and not leaving it to the national human rights institutions only, that the guiding principles won't only be available in the United Nations languages, but as well in all the other languages which are used, for example, by indigenous people. As it has been similarly done in the ILO Convention 169, as far as I have in mind. The guiding principles need not only to be addressed to, but actually reach every single person. Otherwise, exclusion is awaiting us at the end of the road. People need to know their rights first in a language they understand in order to fight for and benefit from that right. Thank you very much.
Thank you very much. We just have two more interventions and then I'll come back to the panel. Ms. Schulthes from the Southern Diaspora Research and Development Center, please. Are you there? Anywhere out there? So difficult to tell in the sea of faces, but I'm assuming she's no longer with us. If you are here and your microphone's not working, please wave your hand. No? Okay, so we'll go to the last intervention, which is Mrs. Wang from the International Graduate School in Zitao.
Hello. Thank you for the opportunity to raise my questions and debates. I think guiding principles are although good guidelines, but they don't have any jurisdiction enforcement for any companies. I mean, when the companies do the violation against human rights, when they don't want to take their responsibility or the accountability, then usually the victims or sufferer cannot do much things to change that. And because in Germany they say also trust is good, control is better. Therefore, I want to ask, is there any possibility of legal punishment exist for violations from multinational enterprise against human rights? And the second question is, could international human rights law and extraterritorial jurisdiction really help the victims and the sufferer to accuse the multinational enterprise? Thank you.
Thank you very much. Professor Ruggie has just gone to enjoy his right to adequate sanitation. We'll be back in a minute. Mrs. Schulthes, are you with us? If that's where it was you've been doing as well and you're back. No? Okay. Right, so I'll go to our panel. We'll go in reverse order, shall we? All right. Reflections, thoughts?
The implementation challenges which face us continue to impress me, and a number of the interventions flagged these. One of the implications, I think, is the degree to which resources will have to be mobilized. We've spoken about capacity building. It's become a kind of catch-all for this category of work. But it's resources in very, very real senses of the word. And there's a burden sharing which is implied in that resource mobilization. The elephant in the room, and Dwight Justice was pointing some of them out to us yesterday, is exactly that cost and its impact on consumer prices, final end prices, the impact on the price paid by the buyer to the supplier, and the wages paid by the supplier to the workers. All of those costs have to frankly be factored into this conversation. Most of the time, most of the resource discussions that I'm in avoid this question. And as a result, we're really fooling ourselves as to how much people can do and whether they will be able to do it, because we haven't been candid about that question. So in the interests of trying to set up a discussion about implementation that is as realistic and as frank as possible, I'd like us to look seriously at the resource question. There's also an expertise question. The expertise involved doesn't exist in many of the supply chains that I travel along and in many of the export platforms that we work in. And we need to find ways of leveraging in that expertise in a way that can really be accessed by the participants at that level. We have some fascinating challenges, some fascinating opportunities in the global supply chain that we just have not been able to take up because of the lack of local expertise. That expertise is best accessed when it's done in a multi-stakeholder forum, we have found. We've seen some examples in, if you take a place like Tirupur in India, for example, which has a water crisis, it has a controversy about labor recruitment and forced labor. And what has happened is that multiple stakeholders have come together to address that. In some cases, it's very late in the day because to date, until now, they were basically fighting about who was responsible. But they have come together now, and we've seen enormous potential in convening those kinds of local stakeholder forums to address some of the overwhelming CSR issues which they face. And I would hope to see us work collectively work together to work out ways of catalyzing the formation of those kinds of local stakeholder forums. And I'm addressing myself particularly to the working group because I'd like you, if you can, to spend some time thinking about what role you can play from the position of, shall we say, moral leadership that you have in helping local stakeholder forums develop in order to address local issues.
Thank you, Aret. Chief Littlechild.
Thank you. I think I will follow the path of discussing the implementation and just offer some quick thoughts on how I think implementation can be assisted by contributions of indigenous peoples. For example, the last question I believe was raised about the possibility of considering issuing the guiding principles in different languages. I think it would be very crucial, for example, that they be done in indigenous languages so that, well, I think the benefits are obvious in saying that, but also the notion of all three pillars moving together forward, we think we can help in that regard as well. Just with two quick thoughts. Free, prior, and informed consent was mentioned in the earlier intervention. And the Special Rapporteur, James Anaya, has done great work in this area of describing what free, prior, and informed consent means, for example, as a safeguard. Consider it this way also, for example, that free, prior, and informed consent is actually a call on all of us to work together. And it's also an opportunity for indigenous peoples to say yes. The last one about conflict resolution mechanisms, the reason why we mention the UN Declaration many times is because the UN Declaration actually is a solution. For example, it provides a conflict resolution mechanism in a cluster of articles right within the Declaration. So we want to underscore that indigenous peoples can and want to contribute to the guiding principles becoming a reality on the ground at home as well. Thank you.
Thank you very much, sir. Anita.
I was struck by two remarks. The last question about access to remedy, I think the answer is, would some of the things you suggested help? And the answer is yes. But we have a long way to go to reform courts, the judiciary, and to deal with extraterritorial jurisdiction as a way of providing access to remedy. So while we all commit to working hard on that, I think another message from the forum was that states can use regulation smartly in terms of extraterritorial regulation to prevent harm. And so we need to do both in order to provide victims with remedy, but to prevent them from suffering from harm. And Adam Green mentioned two things which I think are important. One is, yes, this is not just about foreign investment, this is about national implementation, and I agree. And the second thing he mentioned was corruption and that being a problem for the business environment generally. And so my response back is yes, and I think states have a role to play in recognizing and dealing with that, but there's also a role for the business community to use both issues in their engagement with states and to say that we want to operate in an environment that is both free of corruption, but also one that respects and protects human rights at the same time. So I'd just reply back that the business community has a very big role to play there as well.
Thank you very much. And finally, Sir Mark.
Yes, it's three things basically. The first is on responsible contracting and transparency of contract. I was going to mention it but forgot, and I'm strongly supportive of it, and I think it's an area which business should work with others to make sure that it's practicable, doable, and so on. Secondly is the role of a company in a country in which they may be operating to reasonable standards, but where the government is guilty of human rights abuses, or where, as Adam said, there might be misuse of funds which have been transferred to the government. Leaving aside corruption, in which business indeed has a major role to play, I think it is possible for a company who will or may, if it's a major company, to have significant relations, connections with a government, to use that connection to express opinions on human rights abuses, imprisonment of people, wrongful imprisonment, employment practices, and so on. But it is, and I personally have done that, and it's what I call dining with the devil, because you can only have an influence if the person you're talking to regards you as in some way having an understanding of what problems they have in the country, which is an invidious situation. In order for the bulk of companies to be able to address it, I think I absolutely agree that a safe space is necessary, because there is safety in numbers, and it's safety not only in getting businesses together collectively but businesses themselves are likely to be biased in a business direction. So it's essential to get them together with civil society, because the two sides can keep each other honest, and put together they are much stronger. It's not the only solution, but I go back to my local networks. They don't all work, but any work in that area, they should play a part in it, and I would strongly support it through the Global Compact. And the last one, which is a big thing in the room and mentioned by many people, is legal redress. Companies in general, all the companies I've been involved with, are strongly supportive of strong national regulation, and regulation with as many teeth as you like, applicable nationally, which catches companies of all sizes, persuasions, and origins. That's easy said, and where it works, it's the desired solution. Because the problems occur nationally, and they should be solved nationally, whether they're committed by a multinational or a national or a state-owned enterprise. But we all know that in far too many states, that is a situation which is far from actually happening. And then you get into the question just raised of some kind of international extraterritorial, and that is extremely complex, and I think it will take, shall we say, many years because of the national sovereignty resistances and so on, and the problem that we certainly don't have global regulation, but we don't have a global police force either. And we all know, and personally I dislike intensely, where efforts at global policing have taken us and the human rights abuses that have resulted from that, and which result from things like sanctions and so on. Thank you.
Thank you, Sir Mark. I'm just going to hand back to the chairperson. There'll be a transition period, a very short one, which doesn't, I encourage people not to leave their places or anything. This is just sort of a switch point. John.
Well, thank you, John, for your excellent facilitation, and please join me in thanking the panel. And I now invite the working group to join us up here to share their reflections on what they've heard and what their plans might be going forward.